Former Delhi Deputy Chief Minister Manish Sisodia's bail last week is being hailed as a victory for right to life and liberty. This is especially because we've seen over the past few years how the Enforcement Directorate has really stepped up its game and how the Prevention of Money Laundering Act and its stringent provisions are keeping several accused in jail for long periods of time. But what this order has also shown is that in the past, in the 2 years since the Supreme Court's verdict in the Vijay Madanlal Choudhary case, and I'll get to this case in just a bit, which upheld provisions of the PMLA Act, the Prevention of Money Laundering Act, and the wide powers of the ED, the Supreme Court seems to have delivered a few verdicts slightly tilting the jurisprudence in PMLA cases towards ensuring liberty of the accused. Now, what was the Vijay Madanlal Choudhary case exactly? Essentially, back in 2022, a three-judge bench of the Supreme Court rejected 241 petitions challenging the constitutional validity of certain provisions of PMLA. The judgment, which was viewed as a fillip for the ED, had upheld stringent bail conditions under PMLA, the wide powers of the agency, that is ED, on search and seizure, admissibility of confession statement before the ED, reverse burden on the accused to prove their innocence, and non-supply of the Enforcement Case Information Report, which is ECIR, which is the FIR equivalent for ED lodged before the prosecution. Now, the petitioners in this case had argued that the law, that is PMLA, provided arbitrary powers to the ED, violating fundamental rights like the right to liberty and right against self-incrimination. The verdict, which was authored by Justice A.M. Khanwilkar just 2 days before he retired, has remained contentious ever since because it was viewed as affirming the wide powers granted to the ED. A batch of petitions seeking a review of the Vijay Madanlal judgment is set to come up before the Supreme Court on 28th August. However, since 2022, when this judgment was passed, the Supreme Court has, in several judgments, it seems to have watered down the terse ruling and has tried to sort of find a way around the 2022 verdict, from reminding trial courts and high courts of the principle that bail is the rule and jail the exception, to emphasizing the need for ensuring the constitutional rights of the accused. Now, let me give you a few examples of why I'm saying this. Essentially, let me start with Section 45 of the PMLA, which talks about bail under the law, and it's been one of its most contentious provisions. It says that bail can be granted to an accused in a money laundering case only if two conditions are satisfied. There should be a prima facie satisfaction that the accused has not committed the offense and that he is not likely to commit any offense while on bail. This makes the grant of bail under PMLA extremely difficult. Now, the Vijay Madanlal verdict had essentially upheld these twin bail conditions. So, those charged under PMLA often end up spending a long time in jail due to the stringency of the conditions. However, back in March this year, the Supreme Court orally deprecated the ED, saying that keeping an accused in custody without trial is akin to detention, which hampers liberty. The court took serious objection to the central agency's practice of filing supplementary charge sheets in money laundering cases to defeat the accused person's right of getting default bail. The court's remarks came during the hearing of the default bail plea of Prem Prakash, who is an alleged associate of Jharkhand Chief Minister Hemant Soren. Then, now in its verdict granting bail to Sisodia last week, the apex court's insistence on the principle of bail being the rule and jail being the exception really stood out. The bench, comprising Justices B.R. Gabai and K.V. Vishwanathan, emphasized that speedy trial is a fundamental right under Article 21 of the Constitution, and said that on account of a long period of incarceration running for around 17 months and the trial even not having been commenced, this is, I'm quoting the court verbatim, the appellant, which is Sisodia in this case, has been deprived of his right to speedy trial. The court reiterated that the right to bail in cases of delay coupled with incarceration for a long period should be read into Section 439 of CRPC, which relates to bail, and Section 45 of the PMLA as well. Now, let me give you another example of why a few Supreme Court judgments seem to have worked their way around the Vijay Madanlal judgment. Now, Section 19 of the PMLA says that after arrest, as soon as may be, the person should be informed about the grounds for such arrest. This is in compliance with Article 22 of the Constitution, which says exactly this. It says that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest. Now, in the Vijay Madanlal verdict, the Supreme Court upheld the validity of Section 19 of the law. This was also challenged before the court, holding that the provision has stringent safeguards and that it's not arbitrary. It also ruled that the supply of a copy of the ECIR in every case to the person concerned is not mandatory, and that, like I mentioned, ECIR is the FIR equivalent for ED, and that it is enough if the ED at the time of arrest discloses the grounds of such arrest. Now, the 2022 verdict did not expressly speak about the manner in which the grounds of arrest are to be conveyed, and so the ambiguity in this manner was noticed in several cases. However, the Supreme Court has since brought in clarity on this mode of communication. In October 2023, the Supreme Court granted bail to Realty Group M3M's directors Basant and Pankaj Bansal in a money laundering case, and in doing so, the court brought the much needed clarity in Section 19 by observing that it would be necessary from now on that a copy of such written grounds of arrest should be furnished to the arrested person as a matter of course and without exception. So in the Pankaj Bansal case, the court even noted that the ED had not been following a consistent and uniform practice on the grounds of arrest, because written copies of grounds of arrest were being furnished to arrested people in certain parts of the country but not in the others, where the grounds of arrest were either read out to the arrested person or allowed to be read by them. So it sort of reined in the ED's functioning. The court's interpretation, in fact, then helped NewsClick's editor-in-chief Prabir Purkayastha in May this year, when the Supreme Court declared his arrest illegal and directed his release from custody. While Purkayastha has been accused under various provisions of the Unlawful Activities Prevention Act, which is UAPA, the Supreme Court essentially applied the Pankaj Bansal case judgment to the UAPA case as well. The court noted that the provision regarding the communication of the grounds of arrest to a person arrested contained in Section 43B of the UAPA is the same as that in Section 19 of the PMLA. And now, in another verdict in March 2024, this is just another example for you, the Supreme Court once again clarified the extent of ED's powers of arrest and applicability of the stringent twin conditions of bail under Section 45 of the PMLA. The court ruled that after the trial court takes cognizance of the PMLA complaint, the ED loses its authority and even becomes powerless to arrest the accused under Section 19. The bench was further informed by the lawyers that some special courts under PMLA take the accused into custody after they appear in court pursuant to the summons issued on the complaint. The accused are then compelled to apply for bail under Section 45 of the PMLA, which often fails. But the court opined that such a practice is completely illegal and said that such a practice may violate the right to liberty under Article 21 of the Constitution. So this is how the Supreme Court itself has, in at least a few cases, tried to find a way around the 2022 verdict. A 3-judge bench is now set to consider the review petition against the 2022 judgment. Back in August 2022, a 3-judge bench had limited the review to 2 questions. First, should the ED provide the accused with the ECIR against them? And second, is the reversal of the presumption of innocence constitutionally valid? Also, a separate bench of the Supreme Court is also hearing petitions challenging the validity of Sections 50 and 63 of the PMLA, which pertain to the Enforcement Directorate's power to summon witnesses, extract confession, and press for punishment for giving false information. So we'll of course be keeping an eye on these hearings and orders as well. That's all I have for you today. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.